Export-Import Preference Clauses by Eric M. Jason. Common interpretation. The export-import preference clauses, one cause enrich a person's heart to flutter, but they are critical to the Constitution's adoption. Many in the founding generation were concerned that a strong national government might favor one part of the country or another. Both provisions were responses to that concern. The Export Clause. A fundamental goal of the Constitutional Convention was to ensure that the national government could raise revenue, requisitioning funds from the states under the Articles of Confederation, and failed. Imports and exports were obvious revenue sources, and many delegates, like Alexander Hamilton, saw that the government should be able to tax both. But Southern delegates worried that if geographically neutral uniform taxes on exports would negatively affect the region, the staple states from which most exports came at the time. And they did not hide their fear that export taxation, making agricultural products like cotton more expensive and therefore less attractive, could be used to attack slavery. Export taxation was a deal breaker. Without restrictions, there would have been no constitution. Taxation could conceivably have been limited to particular exported goods, but no agreement on details of that sort was forthcoming. A last-minute attempt to permit taxation of exports, if approved by a congressional supermajority, failed to receive Southern support. That left the clause as we have it today. Only 13 words long, the export clause is packed with imperative questions. By its terms, the prohibition isn't limited to levies that single out exports or that in fact would burden only part of the country. A national tax is invalid as applied to articles exported, period. Articles exported are goods leaving the country. Articles moving from one state to another aren't being exported or imported. The clause is an absolute prohibition. The language doesn't seem to apply only to the national government, but to the clause the clause is in the section of the Constitution restricting what Congress can do. The Supreme Court emphasized that point in 1886 in interpreting the Port Preference Clause. In any event, the Import-Export Clause, Article 1, Section 10, generally limits state taxation of exports as well. Congress cannot circumvent the prohibition by taxing surrogates for exports. Substance controls over form. For example, United States versus IBM, 1996, the Supreme Court held that exercise on premiums paid to foreign insurers was unconstitutional as applied to insurance on exports. In the United States versus United States Shoe Corporation, 1998, the court held that the harbor maintenance tax exercise on port use measured by cargo value was in fact a tax and could not be imposed on vessels engaged in exportation. Not all governmental charges are taxes for these purposes, however. Hence, in the U.S. Shoe, for example, a congressional charge for use of port isn't tax if the charge approximates the value for services provided. Legitimate user fee may therefore be applied to vessels carrying exports. Penalties affecting exportation also aren't precluded by the clause. Courts have crafted rules to determine when a tax falls on article exported. In income tax general application isn't covered. An income tax of general application isn't covered, even so far as it reaches income from exports. A tax on goods at the pre-export stage is also permitted, but once goods enter the stream of commerce leading to exportation, the clause kicks in. A tax on windfall profits from mineral extraction could be permissible, for example, even though some extracted minerals might ultimately be exported. Once headed for export, however, minerals could not be taxed. Stating these rules is easier than applying them, and the few judicial decisions interpreting the clause and models for clarity. Clause may be fuzzy, but is not a dead letter, as the two recent Supreme Court cases show. In any event, focusing on case law can give a misleading impression of the provision's significance. The most important effect of the export clause should be to deter Congress from enacting potentially problematic levies. Port Preference Clause. This clause was intended to constrain the national government's ability to favor ports in some states over ports in others, to the commercial benefit of the former. This wasn't a north versus south thing, that the potential benefit was most likely if the relevant states were neighbors like Virginia and Maryland to their ports competitors. The particular concern was raised in late August by the Maryland delegation, as Luther Martin explained. Without such a provision, it would have been in the power of the general government to have compelled all ships sailing into or out of Chesapeake to clear and enter and Norfolk or some port in Virginia regulation, which would be extremely injurious to Maryland's commerce. Martin admitted it might be in the national interest to prefer Norfolk to make collecting import duties easier, but his delegation wanted to protect its pro-chair interests. Maryland got its way up to a point, but Martin, who became an anti-federalist, came to believe the clause did not do enough to protect his state's prerogatives. Congress might satisfy the clause's literal requirements, he hypothesized, by limiting Maryland to one port and an inhospitable point on the Potomac, effectively requiring Baltimore shipping to stop in Virginia. When Martin was right in his interpretation isn't obvious at its main non-matter. Even without the clause, it's hard to imagine Congress considering legislation like his hypothetical today. Indeed, such a proposal might have been a non-starter in 1789. Besides, Congress can do many things that benefit particular states, but about which the clause is silent. For example, civil military bases have enormous economic consequences, but no provision requires uniform distribution of such facilities. Furthermore, courts have held that consistent with the clause, Congress can incidentally benefit ports in one state, but not in others. For example, by funding infrastructure like bridges, lighthouses. So interpreted, the clause seems to have little effect today. That is particularly so if the term ports is limited to its 18th century maritime meaning, not including other transportation hubs like airports.